Hello, my name is David Winch from Bartfield's Forensic Accountants. And in this session today, we're doing the third part of our 8 questions for the court in confiscation. We're dealing with questions 5 and 6. So let's have a little look at where we are. We will start by just very quickly running through what those 8 key questions for the court are. And then we will look at question 5, which is the defendant's available amount, and question 6, which is what amount should the defendant be required to pay. Then we'll have a very quick roundup of how Bartfield's Forensic Accountants can help you in confiscation proceedings and indeed in other civil and criminal litigation. So the 8 key questions. Question 1, does the court have power to make a confiscation order? Question 2, does the defendant have a criminal lifestyle? Question 3, what is the defendant's benefit? And question 4, how much of the defendant's benefit was obtained jointly? And all of those 4 questions we have already dealt with in parts 1 and 2 of this series of webinars. And the recordings of those, if you want to look through them, are on the Bartfield's Forensic website. I'll be giving you the link at the end. So today we're going to look at what appear to be 2 fairly simple questions. What is the defendant's available amount, and what amount should the defendant be required to pay? And you might think those are quite simple and straightforward questions. They're perhaps not actually in practice quite as straightforward as you might hope. And then in a fortnight's time, we will look at how much time should the defendant be allowed to make payment, and how long should the default sentence be. Okay, question 5 then. What is the defendant's available amount? Some key points. First of all, the defendant's available amount is defined by statute. It's defined in Section 9 of the Proceeds of Crime Act, if you're in England and Wales, and we are talking about England and Wales here. It's not the same as the amount that the defendant has available. It's not what the defendant would think of as what he's got, as it were, spare in order to pay a confiscation order. And so-called tainted gifts may be a major issue in relation to available amount. The burden of proof here rests largely on the defendant to satisfy the court as to what his available amount is. And if he fails to satisfy the court that his available amount is less than his benefit, then the court can make an order for more than the value of his known assets. And it's convenient shorthand to describe that as a situation where the defendant has hidden assets. But that's a little bit of a misnomer, along with a lot of other expressions in confiscation, a bit of a misnomer, in that it's not necessarily the case that the court has considered that there are specific hidden assets. It's simply the case that the court is not satisfied that there are not additional assets available to the defendant. So, thinking about what the defendant has available, let's have a look at his known assets. The defendant's known assets, information about those, is going to come from a variety of sources. First and perhaps most obvious is the defendant's response to the Section 18 order. You remember the Section 18 order is, if you like, the first order that the court is going to make in confiscation proceedings, which is an order requiring the defendant to provide to the court information about his assets, and sometimes other information as well, and sometimes to do various things like provide documents or to repatriate assets to England and Wales if they're outside of the jurisdiction. But the key thrust of the Section 18 order is usually, there's usually a list of questions for the defendant. Have you got this? Have you got that? Give details and so on. And that's going to be the first source of information for the prosecution in putting together their Section 16 statement with regard to the defendant's available amount. But it's not the only source of information that the prosecution will have. They will have obtained information before the trial and possibly during the trial, after the trial, from HM Revenue and Customs, copies of tax returns, that sort of thing. And don't forget that HMRC also can have other third-party information that they can provide to the prosecutor, usually under a request under the anti-terrorism and crime legislation. The land registry too is a source of information to the prosecution, and so are responses to production orders. Don't forget that the Part 8 of Proceeds of Crime Act gives investigation powers, including under Section 345, the ability for the prosecutor to ask for a production order requiring, let's say, an accountant or a conveyancing solicitor to produce their files or copies of their files or documents from their files about the defendant, which can be used by the prosecution in putting together their figures for available amount in their Section 16 statement. And of course, the defendant will make a Section 17 response to the Section 16 statement. So again, that can be a further source of information for the prosecution in terms of the available amount as put at the confiscation hearing. And of course, information might actually come out at the confiscation hearing itself during examination of witnesses. The defendant, of course, might go into the witness box in a confiscation hearing if there's a contested hearing and be cross-examined. And if he hasn't done that at trial, then that will be, if you like, a first opportunity for the prosecution to cross-examine the defendant himself about his assets. In looking at the known assets of the defendant, of course, we have to think about not only what are they, but what value have they? So what are the issues in valuation? Well, according to the statute and according to case law, assets should be valued at market value, and market value means open market price based on a willing seller and a willing buyer. Now, that might seem a little bit odd in the context of confiscation, because at the end of the day, if a confiscation order is made, this defendant is going to be given initially, at most, 3 months to sell assets. So if one of his assets is, let's say, the house that he and his family live in, he's going to get 3 months to sell that. He's hardly a willing seller. He's more in a situation of requiring a rapid sale, and he might obtain less than ordinary open market value. But as far as the Section 16 statement is concerned, as far as the confiscation hearing is concerned, the valuation is supposed to be based on open market value between a willing buyer and a willing seller. It is appropriate in doing this computation for available amount to deduct anticipated costs of sale. So if you're looking at somebody's house which is selling, then there's going to be estate agents' fees, there's going to be solicitors' conveyancing fees, and so on. And it is appropriate for the purpose of calculating available amount, and I stress that, for the purpose of calculating the available amount, not for the purpose of calculating benefit. For the available amount, you can deduct the anticipated costs of sale. So there might be 2 or 3% knocked off there for anticipated legal and estate agents' fees. but you can't knock off taxes. So if you're selling a rented property and there might be capital gains tax to pay on the sale, unfortunately, you're not allowed to take account of that in working out the defendant's available amount. Of course, if he's going to be cleaned out by confiscation, then he's not going to be in any position to pay that capital gains tax when the bill arrives. But that, as you might say, is not our problem. That's a problem for HMRC. I would say sometimes lawyers are a little bit cavalier about valuations. And the reason is that they are thinking that if there's a sale for less than the value they've placed on something, well, they can go back to court under Section 23 and get a variation. That's true, of course, but there are 2 points I'd make about that. One is that if we've got a criminal lifestyle case, we are going to calculate benefit based on, or might be based on, the value of assets held at any time since the date of conviction. And if we overvalue an asset in that computation, then we're going to get an excessive benefit figure, and we're not going to be able to adjust that benefit figure under Section 23. And there may at some stage come along a Section 22 application years into the future, and the defendant is going to be stuck with that benefit figure. So let's not get the properties overvalued at that stage. The other thing is that when you're doing a Section 23 variation, you may not be able to vary the default sentence. If you imagine a situation where somebody's got an available amount of 450,000 based on some estimated sale prices of properties, and the default sentence is set based on 450,000, and then after the event, those properties are sold for much less, and his available amount, let's say, is only 350,000. You might be thinking, well, his default sentence should come down. But if you actually have a look at Section 39, which deals with default sentence on variation, what it says is that the court can, and in some cases must, change the default sentence where the confiscation moves from one band to another in terms of the maximum default sentences. But these bands are very broad. There's a band, for example, 0 to 10,000. There's a band 10,000 to 500,000, a band from 500,000 to 1 million, and a final band of over 1 million. So if we've got our chap who did have 450,000 available amount, or so he thought, or so the court thought, and he's now only got 350,000, well, he's still in the same band. So the court is not going to be able, in that circumstance, to be able to reconsider his default sentence and reduce it. He's going to get the same default sentence on the 350,000 as was fixed on the 450,000. So again, this is why I'm saying we should be a little bit careful to get valuations as far as we can, to get them right first time before the confiscation hearing, rather than trying to come back under Section 23 afterwards. Can I make a little point about mortgages and secured liabilities? Mortgages and secured liabilities give the lender an interest, a legal interest, in the asset on which the debt is secured. And because the lender has an interest in the asset, then the owner's interest in the asset is reduced. And because the owner's interest in the asset is reduced, and because we are only valuing the owner's interest when we're looking at available amount, the defendant's interest, I should say more accurately, then we have to take that mortgage or that secured liability into account in arriving at the defendant's interest. And that is why mortgages and secured liabilities come off in the calculation of available amount. They're not what's called an obligation having priority, that's a different thing, which we'll mention in a minute. They come off because the lender has an interest. Now, I did mention tainted gifts, and tainted gifts can be a problem in relation to available amount. The appropriate value of any tainted gift is added to the defendant's assets in the calculation of available amount. And the logic for that is quite obvious, that if a defendant could give everything away before confiscation, then he'd be able to effectively emasculate the confiscation proceedings by giving all his assets away beforehand, coming along saying, I've an available amount of next to nothing, and what are you going to do about it? So the tainted gifts are added back in almost as if the gift had never been made. I say almost as if, but in some ways it's actually worse than if the gift had never been made, and I'll explain why. Generally, whether a gift is tainted, almost always, whether a gift is tainted depends only on the date on which the gift was made. So in a criminal lifestyle case, if a gift was made after the relevant day, and we know what the relevant day is, it's normally 6 years prior to the date of charge, isn't it? But if the gift was made after the relevant day, then it's a tainted gift. It doesn't matter whether it was actually tainted. It is simply a tainted gift because that is the definition of tainted gifts. In a non-criminal lifestyle case, a gift is going to be tainted if it was given after the date of the offence. Doesn't matter whether it's actually tainted. The prosecution don't have to show it's actually tainted. All they have to show is after the date of the offence, the defendant made a gift, and then it's a tainted gift. The only time where you do need to show where a gift was actually tainted is where it is a criminal lifestyle case and it is a gift made before the relevant day, so prior to the relevant day, but after the starting date of the defendant's offending. And there you do have to demonstrate a connection between the offending and the property gifted, but only there, and it's pretty rare. So tainted gift can be a real problem, particularly as the meaning of gift is extended to include a property transferred at significantly less than market value. So if I have a car today worth £10,000 and I give it to my daughter or sell it to my daughter for £5,000, then that is a transfer at significantly less than market value, and that is then going to be a gift in this context, and can be a tainted gift if it was after the relevant day or after the date of my offending. In that case, it's a gift, if you like, of half a car because it was worth 10,000 and she's paid me half of that for it. But I mentioned right at the start of this slide the appropriate value. And this is where tainted gifts can be particularly nasty, because the appropriate value of a tainted gift is generally the greater of the value gifted at the time, uplifted for subsequent inflation, or the current value of the property gifted. So if, as I say, I've got a £10,000 car, I give it to my daughter or sell it to my daughter today for £5,000, and then 3 or 4 years down the road, I am convicted of an offence, I'm subject to confiscation, and this is picked up as a tainted gift made after the relevant day. The value of the car by that time will be very much less than the value of the gift. But that doesn't matter, because in calculating my available amount, the value gifted is taken and uplifted for changes in the value of money. So the value of the tainted gift in my available amount will be more than the actual value of the car at that time. And that is a potential nasty trap. It also means that my daughter's assets, all of my daughter's assets, will become realizable property as far as enforcement is concerned. So all sorts of difficulties from tainted gifts. I mentioned obligations having priority. Well, what are they? They are thankfully rare. They are defined in section 9 and they're limited to fines and similar sums due under court orders following conviction for an offence. So not civil court fines, civil court penalties or anything like that, or damages or whatever. We're talking about fines or sums due following conviction for an offence. And debts which would be preferential in a bankruptcy, such as if I'm a sole trader with employees, then I've got employees' wages to pay. If they're left unpaid, that's a preferential debt. That is an obligation having priority. That will come off my assets in calculating my available amount. But as you see, those are going to be relatively rare. Let's talk about hidden assets and the burden of proof. The burden of proof broadly rests on the defendant to satisfy the court that his available amount is less than his benefit. And if you look at subsection 2 of section 7, it says, if the defendant satisfies the court, so that places the burden on the defendant. It's understandably not the job of the prosecutor to go chasing around the country trying to find what my assets might be if I'm a convicted defendant. But what if the court doesn't believe my evidence? If I'm the convicted defendant, if I go into the witness box and say, Your Honour, I have no assets, and I'm not believed. Well, is the court then bound to assume that my available amount is at least the amount of my benefit? Well, no, it's not. What the court is then required to do is to look at the case on the basis of the facts as a whole. So even where the defendant has given no evidence or his evidence has been absolutely disbelieved, the court is going to look at the evidence of their case as a whole and form a view as to the defendant's available amount. And there is the well-known case there of McIntosh, which is on the slide. But if the court's not satisfied that my available amount is as little as I say, then it can fix an available amount which might be equal to the total of the benefit, or it might be somewhat less than that, but more than the assets that I'm saying I have. And that was indeed what happened in the McIntosh case. The court can then fix an available amount of known assets and tainted gifts, which is more than my known assets that I'm admitting to. And for convenience, we refer to the excess, to the difference, as a hidden asset. But it's not meaning that the court has identified a specific asset which is hidden necessarily. It's simply that the court is fixing my available amount at a figure higher than the assets that I am admitting to. Now, there is a case that prosecutors sometimes love to quote, and it is there's a quote I'm going to give you which sounds like it's all the prosecutor's Christmas is wrapped up in one. It's a case, I call it Barwick. I don't know, perhaps it should be pronounced Barwick. But anyway, case from 2000. It was actually a case on the Criminal Justice Act 1988 confiscation provisions, but it's applied equally under POCA. And there's this lovely quote: "It is permissible and ought normally to be the approach of the court to conclude that the benefit remains available until the defendant proves otherwise." And that gives you the impression, doesn't it, that the court should fix the available amount at the amount of the benefit unless the defendant proves otherwise. But let's look at that a bit more carefully, because that was actually a very straightforward case. The defendant there was a con man who stole money from people by conning them out of money which they gave him. He was the only defendant. It wasn't a conspiracy. There were no co-defendants. There were no statutory assumptions made. The benefit in his case was quite simply the amount of money he'd stolen. And of course, the court quite properly then said to itself, well, where's the money? You've had that money. Where is it? It must be in your available amount, unless you can show us that it's not. But in many cases under POCA, there's all sorts of things in benefit which don't correspond to a realizable asset. They're not like the cash that this guy had conned out of people. For example, if you've got a drugs case, you can have a benefit of a large value of drugs, but there is no realizable asset there because those drugs, of course, can't be sold. So the available amount is immediately going to be less than the benefit. And I had a case recently where a defendant had a benefit well into 6 figures, and his available assets were relatively trivial, and the prosecution wanted an order in the amount of the benefit. I'm pleased to say that at the end of the day, we looked at those areas of benefit and we said, well, no, these benefits that we look at don't provide him with an available amount. And the court ultimately made an order based on the trivial assets that he admitted to and set a default sentence of 7 days. So huge relief for him in getting a decent confiscation order with a very small amount to pay, although he had a large benefit. And of course, there's section 22 for another day. Okay, so question 6. This one would think is perhaps the most straightforward question of all. What amount should the defendant be required to pay? Well, the statute defines what's called the recoverable amount. And the recoverable amount is the lower of the benefit or the defendant's available amount. And you might say, well, job done. You've 2 numbers, you pick the lower one. Well, the court must then order the defendant to pay the recoverable amount unless nothing is quite straightforward in confiscation, is it? So there's an unless comes here. The court must order the defendant to pay the recoverable amount unless it would be disproportionate to do so. And disproportionality or proportionality has nothing to do with hardship, has nothing to do with, oh, let's be nice to this poor defendant who's we don't really want to ask him to pay a lot of money. No, the thrust of proportionality is not about hardship at all. What it is about is that it would be disproportionate for the defendant to have confiscated from him either benefit which he already has or will fully make good to the victim. For example, where a stolen item is returned intact. If I steal a painting from an art gallery and they recover it and it's intact and they've got it back, it's disproportionate then to ask me to pay the value of that as in confiscation as a benefit. It will be a benefit, but it shouldn't be. I shouldn't be asked to pay that again because effectively it's a double penalty because the painting has gone back to its owner. And similarly, a loan fraudulently obtained, if that's repaid, then although it's a benefit, it's not one that I should be required to pay in confiscation because the lender has lost nothing and I've repaid it. And the second area where we get proportionality issues is where a benefit has already been paid to the state. For example, VAT, which the defendant has accounted for to HM Revenue and Customs. If the defendant's in business and he's been operating a dodgy business, but he's been accounting for VAT on the sales of, let's say, counterfeit cigarettes, If he's been accounting for the VAT on that to HMRC, then it would be disproportionate for him to have to pay that again by way of confiscation. So in terms of calculating the amount he's to be ordered to pay, you're going to knock out of that benefit the VAT, which he's already accounted for to HM Revenue and Customs. And similarly, of course, the more common one, where a sum has been recovered from a co-defendant in respect of benefit jointly obtained at the same time. We discussed that in question 4 a fortnight ago. Again, there it would be disproportionate for the state to recover that twice over. Okay, so that's done questions 5 and 6. Let me very briefly remind you of how Bartfield's forensic accountants can help you. We continue to be fully staffed. We're undertaking legally aided and privately funded criminal and civil forensic accountancy work. We're doing it remotely, online, using our up-to-date and secure IT facilities. And we do, of course, remain readily contactable by phone, by email, and online. The recently updated website is full of useful information, and you can find more on this topic in our blog articles, which are on the Insights section of the website. And this and previous webinars, recordings of them, are available on the seminars section, webinars and seminars section of the website. You will actually be sent a free recording of this webinar in the next few days. And if you need to contact me, do feel free to email me is best. My email address is there in front of you. If you phone the office, I am unlikely to be there to answer you straight away, but you will be able to leave a message for me. But as I say, if you email me, particularly if there are relevant documents, I will happily look at that and get back to you as soon as I possibly can. Okay, so that is us done for today. We will be back in a fortnight with the final 2 of the 8 questions for the Crown Court in a confiscation. Thank you very much for your time. I'll see you in a fortnight. Thank you. Bye.